You good? Yeah, he's good, Mr. Roseman. And we'll put clerk instead of bailiff. Clerk Kim. Uh-oh. Tell Judge don't come out. I can't, it keeps going away. Ah. Well, it tested good today. I gotta shut down.
It's gonna be just a second, gentlemen, so just hang tight for a few minutes.
All right.
55th Circuit Court is now in session with the Honorable Roy G. Mink presiding.
You may be seated. On the case, the People versus Timothy William Calloway. Counsel identify for the record.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Good morning, Your Honor. Gerald White, representing Mr. Calloway.
And you are Timothy William Calloway?
Yes, I am, sir.
All right. This was set for a probation violation status conference. You've had a chance to talk to your client this morning, Mr. White?
I have, Your Honor. Thank you.
All right. And he's on probation for assault with a dangerous weapon, a felony that carries a maximum penalty of 4 years. Amended bench warrant has 13 counts on it. Is there anything you wish to do today regarding this, Mr. White?
Yes, Your Honor. I'm going to be asking for an adjournment over for a period of about 30 days to discuss this matter with Agent McConnell. And he needs time to do additional research into Mr. Calloway's background to make any kind of a recommendation to the court, depending upon how we resolve this case. So I'm asking the court to set this matter over for a period of approximately 30 days, whatever is appropriate for the court. And I have no objection from my client.
Okay. I believe he's previously waived the 14 days, so we'll go ahead and grant that adjournment and set it about 30 days out. Anything further?
No, I don't think so, Your Honor.
All right, we're in recess.
Thank you.
I wanted to suspend it. No insurance. That way I can justify it in case I'll find that charge. Well, I couldn't.
Okay, cool.
I'll save myself. I don't mind working if there's a product, like if there's a reason, but it's pointless. I don't get anything from it. No. Be on this one?
All rise. Could we have second call for the coming Gladys now session? The Honorable Roy G. May presiding.
You may be seated. Calling the cases of Dick versus Kevin Corey Skaggs. Jr.
Good afternoon, good morning, Your Honor, Norman Gage, Superior on the prosecutor's office.
Morning, Your Honor, Karen Tomczyk, appearing on behalf of Mr. Skaggs.
You are Kevin Corey Skaggs Jr.
Yes, Your Honor.
Previously, you appeared in court and pled to the charge of malicious destruction of police or fire property. That's a felony. It carries a maximum penalty of 4 years in prison, minimum discretionary with the court. A pre-sentence investigation report has been prepared. Sentencing guidelines are 0 to 9 months. Ms. Tomczyk, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert in that report?
No, Your Honor.
On behalf of the prosecution, anything regarding the factual nature of the report?
Your Honor, I've had the opportunity to review the pre-sentence investigation report. I'm satisfied with its contents, have been updated, and I've run through the supporting guidelines. I believe prior record very proper support, although I believe it could be made with regards to 2019. I'm satisfied with the support. We would not ask to make any changes to that.
Mr. Skaggs, is there anything you wish to say to the court before the court passes sentence?
That I just hope I don't do any more jail time because I've been trying to do so good out there. I finally got a job. I've been kind of happy that I got a job, and now it just feels like I'm going to lose it all because I'm back in this predicament, and I don't want to. I want to be out there as a rehabilitated citizen and be a good person. Don't mess up and follow the law and respect and help the law.
Tomczyk, on behalf of your client?
Thank you, Your Honor. And in noting Mr. Skaggs, he does better when he does have employment, Your Honor. I know that apparently he's sitting on a new charge that none of us were aware of. The court had granted him personal cognizance bond yesterday. I would ask that you follow the recommendations, Your Honor, and give Mr. Skaggs additional probation and allow him to show the court that he can maintain what he has been maintaining. He's trying very hard, I think, to the best of his ability to do well.
Mr. Gage, on behalf of the people?
Your Honor, this is one of those cases where it would really be easy to ask the court to just lock Mr. Skaggs up before we get a key. And I've done a lot of conversation with Mr. Martis, the probation officer that's been proceeding. And it does appear in the last couple of months that Mr. Skaggs has made some progress. And so I'm going to ask the court to follow Mr. Martis' recommendation with the research report. See if he can continue to make progress with Mr. Skaggs. I waited at the gate for Mr. Skaggs arranged yesterday in district court on the charge of driving under suspended license. A civil action for insurance. I don't think we should radically alter what it does in this case. Mr. Skaggs needs to deal with his emotions and his impetuousness. If it doesn't have abandonment, he has himself under control. He loses control very easily and thus gives himself very trouble.
Are there any victims present that wish to speak to the issue of sentencing? Let the record reflect there are no victims present either in the courtroom or by Zoom. Any wish to speak? For the purposes of today's hearing, Ms. Tomczyk, Mr. Skaggs is waiving the right to be present in the courtroom, is that correct?
Yes, Your Honor.
Court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 0 to 9 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts in protection of the community, would be the sentence of this court. That you be placed on probation for a period of 2 years, long as the statutory term for probation, have the following special conditions. Must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. And to that end, the court wants Mr. Skaggs to do anger management counseling. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not use any object as a weapon. You must contact your supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. Must submit to a search of your personal property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must pay restitution in the amount of $643.62. Comply with DNA testing and pay a $60 fee if that has not been done before. Pay a $68 state cost, a crime victim's assessment of $130, court costs of $500, a fine of $500. How much are you charging for attorney fees?
For this case, $880.
$880 for court-appointed attorney fees. You must enter an installment payment agreement with the Glen County Clerk's Office for the payment of those fines and costs. The probation officer may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to prevent an appeal. The request for the appointment of an appellate attorney must be made in writing within 42 days and directly to the court. Please sign the notice of appellate's rights form. Bond is canceled. Good luck to you on that, Mr. Skaggs.
Now, is that for just this case, Your Honor? Because I do have a
That's
question.
just this case, just this case. Now we gotta talk about the probation violation case, because apparently I don't see that he's pled any charge of the probation violation, has he?
That's correct. There is a plea agreement.
And he was facing, violation of Rule 1 regarding domestic violence, violation of Rule 1 on assaultful behavior, violation of Rule 1, the MVOP of police property. I guess that my preference is, at this point, to just dismiss all those, but extend his probation another year.
That's fine with us.
And-
That would be fine. Is it to run concurrent with his new probation, Your Honor?
Yeah,
Okay. There's no objection to that, Your Honor.
all right. So you're all set, Mr. Skaggs. Once you get out, continue to report, continue to work, and start, make payments on your fines and costs.
I'm gonna put $200 every month on my fines and costs, but I do have one question for you, Your Honor. During this case, I wasn't able to talk to my wife and it's been killing me hard. And I just am hoping that our restraining order or whatever was put on us is lifted so I can start seeing her again.
What's the status of that, Mr. Mars?
And I believe that was only a bond condition, so that I don't recommend that there be a probation condition to the same effect as a bond.
So that bond condition is off, Mr. Skaggs, okay?
Okay, so when I get out of here, I can go see my wife?
I believe so, unless there's some other bond or PPO issued against you, which I don't know of.
That was just it, Your Honor.
I am not aware that there's a PPO.
Yeah.
Mr. Skaggs, you just need to make sure that, she doesn't have any other condition on her.
She's been trying to get it off for the last 5 years that we've been dealing with this case. She told my dad that she's got everything set. It was just put on me because I guess it was part of my bond condition.
Correct, right, and you're not on bond anymore, Mr. Skaggs, okay?
Okay.
The bond on that, Judge. Mr. Skaggs, can we get Mr. Shumway, please? Donald Lee Shumway.
I hope you have a good.
We could upstairs to talk about it.
Well, in the cases of people versus Ronald Lee Shumway Jr.
Good morning, Your Honor. Norman Cage, Premier, behalf Prosecutor's Office in both files.
Morning, Your Honor, Carroll Township, Craig, we have Mr. Shumway in both files.
You are Ronald Lee Shumway Jr.?
Yes, sir.
And how old are you?
40 years old, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Mr. Shumway, have you received copies of the informations and amended informations or gone over those with your attorney in these cases?
Yes, I think so.
Ms. Township, for purposes, what'd you say?
Can I have a moment with her, maybe?
Sure. All right, we're in recess.
All right.
Yeah, he's gonna chat with me. I know.
Pleasure.
All right. Fifth Fifth Circuit Court for the County is back in session with the Honorable Roy G. Mink presiding.
All right, you may be seated. Recalling the cases of people versus Ronald Lee Shumway Jr. Got enough time, opportunity to talk to your client, Ms. Township?
I have, Your Honor.
Are we going to continue with the plea procedures?
We are, Your Honor.
And previously, your client waived preliminary examination in both cases, is that correct?
That is correct, Your Honor.
Mr. Shumway, you're being charged with file number 21-11020-FC with count 1, controlled substance possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison. and or $15,000 fine unless sentenced to more than 1 year in prison. The court shall impose license sanctions. You're also being charged with count 2, jails, prisoner possessing contraband, that's a felony, carries a maximum penalty of 5 years in prison and or $1,000 fine. The minimum is discretionary with the court. In file number 21-10951-FH, you're being charged with count 1, weapons, taser, possession or sale of, a felony that carries a maximum penalty of 4 years in prison and or $2,000 fine, mandatory forfeiture of the weapon or device. Otherwise, the minimum is discretionary with the court. You understand the charges and the possible penalties?
Yes, Your Honor.
There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand that one of 3 possible pleas you may make?
Yes, Your Honor.
Answering in file number 21-11020-FC to count 1, controlled substance possession of methamphetamine, how do you plead?
Guilty, Your Honor.
Answering to count 2 in that file, jail, prisoner possessing contraband, how do you plead?
Guilty, Your Honor.
Answering in file number 21-10951-FH to count 1, weapon, taser, possession or sale of, how do you plead?
Guilty, Your Honor.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, Your Honor.
Mr. Gage, what is the plea agreement?
Your Honor, starting with file 21-11020-FC, in return for the defendant's guilty plea and defamation count 1, possession of methamphetamine, and count 2, jails, prisons, possessed contraband, and same, by the court's acceptance of that plea, pronouncing sentence and running the appropriate appeals period, the people would ask the court to dismiss the habitual 4th notice and the second or subsequent offense notice. In file 21-10951-F8, in return for the defendant's guilty plea to count 1, possession or sale of a taser, of course, acceptance of that plea pronouncing sentence, and running the appropriate appeals period, the habitual notice will be dismissed. The defendant will be responsible for restitution as found appropriate by the court. The sentences in this matter will be concurrently. In addition, Your Honor, the defendant has several matters in district court. He has a plea down there as part of the plea in this case to 1 file and remaining files disposed of through that. Finally, Your Honor, the defendant will be responsible for restitution if there is any as found appropriate by the court.
Ms. Tomchak, is that your full complete understanding of the plea agreement?
It is, Your Honor.
Mr. Shumway, did you hear it was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about May 26th of 2021, were you in the township of Grout, Gladwin County, Michigan?
Yes, sir.
And did you have a portable device or weapon from which an electrical current, impulse, or wave or beam was designed to temporarily incapacitate, injure, or kill. A taser, did you have one?
Yes, sir.
Did you have any special license or permission to have that in your possession?
No, sir.
Directing your attention to on or about June 4th of 2021, were you in the township of Grout, Gladden County, Michigan?
Yes, Your Honor.
And at that time, did you have some methamphetamine in your possession?
Yes, Your Honor.
And you knew it was methamphetamine?
Yes, Your Honor.
Did you have any license or permission to have that in your possession?
No, Your Honor.
And at that time, were you brought into the Gladden County Jail?
Yes, Your Honor.
And when you were in the jail, you had that in your possession?
Yes, Your Honor.
And you failed to tell the guards that you had that in your possession?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Gage?
I am, Your Honor, in both cases.
Satisfied with the factual basis, Ms. Tomchek?
I am, Your Honor.
Let's court apply the court rules, Mr. Gage.
The court has, Your Honor.
Let's court apply the court rules, Ms. Tomchek.
It is, Your Honor.
Court has not agreed on how the possible plea or the possible sentence of either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate and that freely, voluntarily, understandingly, and knowingly made. Pleas are accepted in order to enter upon the records of this court. Sentencing will be set for October 18th at 1:40 PM. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is canceled. The case is adjourned to the date time set for sentencing. Thank you, Your Honor.
Your Honor, in discussing of bond, if Mr. Shumway does get into a rehabilitation center with the court, entertain a motion to allow him to go.
Court will entertain a motion at that time. You're all set, Mr. Shumway, for today. Thank you. Okay, George. Well, we have a bond violation on Shumway Celestino. In the case of the people versus Daniel Lorenzo Davis Celestino, counsel identified for the record, please.
Good morning, Your Honor. Norman Gage, appearing on behalf of the prosecutor's office.
Louis J. Rolford, 127 North Arcade Street, appearing on behalf of Mr. Celestino, Your Honor.
You are Daniel Celestino?
Yes, sir.
And you're here today, you've been arrested for a bond violation. That's a contempt of court charge, carrying a maximum penalty of 93 days in jail and or a $500 fine. Minimum's discretionary with the court. How do you wish to proceed today, Mr. Wilford?
I just was informed approximately an hour ago that Mr. Celestino had been arrested and that they was going to be having this hearing. I have not been back to my office to pick up the file or to, in fact, have an opportunity to discuss it with Mr. Celestino. I would suggest that Mr. Celestino enter a plea of standing duty at this point.
All right. Not guilty plea will be entered on behalf of Mr. Celestino. As to the bond that should be set in this matter,
Your Honor, if I may, Mr. Celestino entered a plea to what he was sentencing. I think it's appropriate at this point in time, his bond would be revoked and not be reinstated. The allegations of good charge has been charged with another home invasion count. It is alleged, I emphasize alleged at this point in time, that Mr. Celestino went back to the home of his estranged wife and broke into her house again. It was done inside the house and went out and rummaged through her car. All of that is violation of bond condition in another case where his estranged wife again was victim of this act of home invasion and domestic violence. It's not a hard rule of contact custodians of the property. Mr. Celestine was demonstrated that he has difficulty following those, simple rules. Frankly, Your Honor, when I get, most of the information or request yesterday, I intend to look at possibly install the church.
Any comment, Mr. Wolford?
My only comment, Your Honor, is that because he has entered a plea, it is my understanding that he's not absolutely entitled to a bond, and at the time, the court just continued the bond, and I would suggest that it, as opposed to revoking the bond, that it be canceled. It's effective, it means the same thing, except that I believe they would be entitled to receive the credit for it, whatever that might be.
All right, the court will just cancel the bond. We're not gonna forfeit it or anything. It's fine, it'll just be canceled. Thank you, Your Honor.
Thank you, Your Honor.
We're in recess.
All right. 7 o'clock.